judgment in the matter of the Queen on the application of D.N. Rwanda versus Secretary of State for the Home Department.
Lord Kerr will explain the judgment.
Well, I apologise in advance for the overly technical, but inevitably technical nature of the summary that I'm going to give of this case. In this appeal, D.N., who is the appellant, is a Rwandan national. He was granted refugee status in the United Kingdom on the 26th of October 2000. Subsequently, he was convicted in this country of certain offences. The most serious of those occurred on the 22nd of January 2007 when he pleaded guilty to assisting the unlawful entry of a non-EEA national into the United Kingdom. That was contrary to Section 25 of the Immigration Act of 1971. He was sentenced to 12 months imprisonment for that offence and 2 months consecutively for each of 3 pecuniary advantage offences, so that he was required to serve a total of 18 months imprisonment. Now, the Secretary of State for the Home Department has powers under the Nationality, Immigration and Asylum Act of 2002 to order the deportation of persons convicted of serious offences. And Section 72(4)(a) of that Act provides that a person shall be presumed to have been convicted of a particularly serious crime and to constitute a danger to the community of the United Kingdom if she or he is convicted of an offence specified by the order of the Secretary of State. The Secretary of State specified several offences which were said to be particularly serious crimes, and he did that under what is known as the Nationality, Immigration and Asylum Act 2002, Specification of Particularly Serious Crimes Order 2004, normally referred to as the 2004 Order. Assisting unlawful immigration, contrary to Section 25 of the 1971 Act, was included among the offences which were specified in the 2004 Order. At the end of his period of imprisonment, of D.N.'s period of imprisonment, the Secretary of State made a decision to deport him, and that was based on Section 72(4)(a) of the 2002 Act. D.N. was presumed, on the basis of the 2004 Order, to have been convicted of a particularly serious crime and to constitute a danger to the community. And on the 31st of January 2008, the Secretary of State, using his powers of administrative detention under paragraph 2.3 of Schedule 3 to the Act, ordered that D.N. be detained pending his deportation. D.N. then brought a claim for a judicial review of the deportation order. And because of a decision of the Court of Appeal in a case called E.N. Serbia against the Secretary of State for the Home Department, which determined that the 2004 order was unlawful, D.N. amended his judicial review proceedings to concentrate on the lawfulness of his detention. Following a stay of the judicial review proceedings and another decision in the Court of Appeal called the Queen on behalf of Draga against the Secretary of State for the Home Department. In that case, the Court of Appeal had ruled that the detention was lawful even where based on an unlawful deportation order. And on the basis of that decision, the Court of Appeal in the present case dismissed D.N.'s substantive appeal. He has appealed to this court. The Supreme Court unanimously allows the appeal. It holds that the appellant was unlawfully detained and that he is entitled to pursue a claim for damages for false imprisonment. First, we noted that in the case of Lumba, which was a decision of this court, Lord Dyson had made it clear that there's no difference between a detention that's unlawful because there was no statutory power to detain and a detention which is unlawful because the decision to detain was made in breach of a rule of public law. And here, as in Lumba, there was no statutory power to detain. The 2004 order upon which the decision to deport was based was ruled unlawful in EN Serbia, and its detention was for the express purpose of facilitating deportation. Without a lawful deportation order, the occasion for detention simply does not arise. Second, detention is entirely dependent on the decision to deport. The DN's detention in this case was uniquely linked to the deportation order, and without a lawful decision to deport, the question of detention cannot arise, much less be legal. The lawfulness of detention is always referable back to the legality of the decision to deport, and this is not an instance of a series of successive steps, each having an independent existence. For this reason, the Court does not accept the argument that the independent judicial decision made in statutory appeals under Section 82 of the 2002 Act was a step removing the legal error in question. Indeed, we say that the rubric chain of causation is inapposite in this context. This Court considers that Draeger was wrongly decided for the reasons given by Lord Carnwath, with which I agreed, I and the other members of the Court agreed. Further, the Court considers that if, so much as the case of Ulla suggests that paragraph 2.2 of Schedule 3 to the 1971 Act provides standalone authority for lawful detention, no matter what has gone on before, and irrespective of the fact that the decision to deport lacks legal basis, inasmuch as Ulla suggests that that decision too was, in the opinion of this Court, wrong. Lord Carnwath considered that issue estoppel, if argued, could have provided the answer to this appeal. DN's private law claim for damages depended on the lawfulness of the deportation decision at the time it was made. And in his opinion, that issue was conclusively determined by the decision of the tribunal in August 2007 and the decision of the High Court rejecting the application for review. Lord Carnwath pointed out that DN had the opportunity to challenge the legality of the original deportation decision by reference to the invalidity of the 2004 order, but he didn't do so. Hence, it could be said that he could be stopped from challenging at a later date. But Lord Carnwath did observe that since the Secretary of State had not relied on issue estoppel or res judicata, it would be unfair to DN for the Court to introduce it at this stage. The other members of the Court decided that they should not express even a tentative view on this interesting argument.
Thank you. The Court will now adjourn.